Good afternoon and welcome to the Dorsey and Whitney Energy Industry Group webinar on innovation, the power industry, and antitrust. Before we get started, I would like to remind those attorneys listening in today who need CLE credit to please print out the sign-in sheet that was sent with the reminder and PowerPoint yesterday from Dorsey and Whitney. Instructions for completing the form are included on the form itself. If you have any questions during the webinar today, please send those questions to dorseyu@dorsey.com. That's dorseyu@dorsey.com. We will monitor this email box and respond to your questions at the end of the presentation. If we run out of time, we will respond by email. Now that I've been talking for a moment or so, let me introduce myself. My name is Michael Lindsay. I'm a partner here at Dorsey and Whitney and am a member of our Energy Industry Group. I serve as co-head of the firm's Antitrust and Commercial Litigation practice groups. I've been practicing antitrust law for about 30 years in litigation, merger review, standards development, and counseling. And I've worked with electric utilities and electric cooperatives for the last 2 decades. I serve on the editorial board of the ABA Antitrust Section's Antitrust magazine, and in addition to my day job, I've taught antitrust as an adjunct professor at the University of Minnesota and the University of St. Thomas. Now let me also introduce my co-presenter, Phil Hanser. Phil is eminently qualified to discuss our topics today, and not just because he also wears glasses and a bow tie. Phil is a principal of the Brattle Group and has over 35 years of consulting and litigation experience in the energy industry. His focus is on regulatory and financial economics, especially for electric and gas utilities, as well as various matters ranging from market power analysis and contract breach litigation to the application of statistics in regulatory and litigation settings. He has testified as an expert witness before FERC, as well as numerous state PUCs, environmental agencies, federal and state courts, and arbitration panels. He is a member of IEEE, the Institute of Electronics and Electrical Engineers. He's taught at the University of the Pacific, UC Davis, Columbia University, and he has guest lectured at MIT, Stanford, and my alma mater, the University of Chicago. In addition to his position at the Brattle Group, he is currently a senior associate in the Mosavar Rahmani Center for Business and Government at Harvard's Kennedy School. The views that Phil and I express here will be our own views, and we are not speaking on behalf of our respective firms or their clients. Let me briefly describe the agenda that we will follow today. First, we're going to provide a brief refresher on some antitrust concepts with some illustrations from the power industry. We're then going to talk about innovation, pricing models, and distributed generation. We'll discuss a couple of recent cases, the Salt River case and the Merced case, and then discuss a couple of hypotheticals, and time permitting, respond to questions at the end, or as I noted earlier, respond by email. So let me start just by talking about some key antitrust law prohibitions. Antitrust law prohibits agreements that unreasonably restrain trade. It also prohibits monopolization and attempted monopolization, and mergers and acquisitions that tend to substantially lessen competition. We're going to focus on the first 2 of those prohibitions in our program today. And I want to note as well that the focus of our presentation will be federal antitrust law, but utilities and other listeners would also want to bear in mind that antitrust claims can be brought under state law and in state court, and that may involve activities that are regulated by FERC and therefore implicate preemption and jurisdictional issues as well. Agreements in restraint of trade. Some agreements are per se or automatically illegal. For example, a group of manufacturers getting together to fix the prices at which they will each sell products that they would otherwise be selling in competition with each other. Classic case, horizontal price fixing is automatically illegal. Other agreements are judged on a facts and circumstances basis. It used to be that just meant the rule of reason, which was the highly intensive fact analysis, looking at exactly what was going on in a particular market and trying to determine whether on those facts an agreement was net pro-competitive or net anti-competitive. Over the last 20 years or so, the U.S. Supreme Court has also provided something called the quick look doctrine, which is somewhere between the per se rule and the rule of reason. And it's really becoming more of a sliding scale. But the common theme in all of this is to look at the effects on competition. In the hardcore price fixing case, we know that there will either never or almost never be sufficient pro-competitive benefit for us even to bother looking further. And at the other extreme, we know that it gets a lot more complicated. Generally speaking, most but not all problems arise from agreements with competitors, horizontal agreements, and very few, but some problems arise from agreements with suppliers or resellers or vertical agreements. Now let me just define monopolization a little bit more. Monopolization is different from merely having a monopoly. A monopoly can result from superior products, better service, more innovation, and companies should not be punished for their success. And obviously in a regulated industry, the monopoly can be granted by state statute. The offense of monopolization requires additional conduct that is beyond merely having the monopoly. It requires conduct to preserve or obtain that monopoly. Generally speaking, that falls into two categories: something that excludes rivals from entry or expansion in the market, or something that raises their costs of entry or expansion. A few examples, and then we'll turn to some actual cases from the power industry. The concept of tying, that is conditioning my sale of product A on the customers also buying product B. Or exclusivity provisions in resale agreements sometimes can be a form of monopolization, and sometimes a refusal to deal, although, as we'll discuss later on, the circumstances in which that happens may or may not obtain in a particular set of facts. Now let me talk about an example of an agreement of restraint of trade in the power industry. A university was considering building a new steam, heat, and cooling plant, which was also going to co-generate electricity more than the university needed. The utility in that area promised to provide the university electricity at a reduced rate in exchange for the university's promise not to compete against the utility in the sale of electricity to consumers. The Justice Department sued the utility, which ended up consenting to a court order that prohibited the utility from enforcing that clause or entering into similar clauses. And the point here is that the university was a potential entrant into the business of generating and selling electricity to consumers. The nature of the agreement was an agreement that the university would not do that in exchange for the equivalent of a monetary payment. Now, this is different from an agreement or a refusal or some kind of condition on the terms of access that the university might have had in order to get its electricity out onto the grid so that it could sell to consumers. And that's an important distinction that we'll discuss later on. Now let me give a couple of examples of monopolization in the power industry. In this one, a utility serves municipalities in its service territory. Some of those municipalities voted to create municipal power services when the utility's franchise expired. The district court found that the utility had refused to supply electricity to the municipal power systems and refused to wheel electricity from third-party sources. The U.S. Supreme Court affirmed and held that refusals to sell at wholesale or to wheel, at least in this particular case, were solely to prevent municipal systems from eroding its monopolistic position. But the court did recognize the strength of the utility's argument that a compulsory interconnection will erode the utility's integrated system and threaten its capacity to serve the public adequately. And the Supreme Court noted that the district court had tried to accommodate that legitimate concern by conditioning interconnections on approval by the then Federal Power Commission. So to summarize, the conduct at issue here that the court found sufficient to support a finding of monopolization was the refusal to sell electricity and the refusal to wheel third-party electricity. Now that case was almost 50 years ago. Here's a more recent example. In this case, a municipal utility provided service within its city limits and a co-op provided service outside the city. The building of a new jail was announced located just outside the city, and the city then annexed that area, which under state law, as I understand it, allowed the municipality to issue an offer of service, but it didn't prevent the co-op from also issuing an offer of service. The co-op service offer was superior to the municipal's offer, according to the pleadings, but the municipal refused to provide any sewage services to the jail unless the jail also bought the city's electricity. And I love the quote from the court: finding themselves stuck between a rock and a pile of sewage, the operators of the jail reluctantly went with the city's package deal. So the conduct there is an example of tying the refusal to sell one product over which in this case, the city had apparently a monopoly unless the customer also bought the second product. Now we're going to talk about innovation in energy, and let me turn this over to Phil.
Thank you, Michael. There certainly has been significant innovation in energy, not actually in some sense starting at the meter with new AMI technology and going all the way through to customer-side generation on the other side of that meter. And probably the leading innovation, at least as measured by the volume of transactions associated with this, probably solar panels. There are other innovations in the future. For example, we have a very small picture in these slides of a combined heat and power system, which uses a fuel cell. And there have been other proposals for how such combined heat and power systems could operate. I want to start with a kind of contrast between what happens outside the utility industry, and then we'll talk about what happens inside the utility industry. Outside the utility industry, the standard pricing model is essentially to set price so that it exceeds unit cost. Of course, in a competitive industry, those prices are subject to competitive pressures. Alternatively, and most often, we often see a kind of what I would call product line pricing. In product line pricing, the company typically has a whole variety of products. Sometimes, in order to add prestige, for example, to its product line, it will produce a deluxe or somewhat fancier version of whatever product it standardly produces. Often, those products are priced such that their unit costs exceed their price. The company, on the other hand, by having this additional breadth, perhaps by adding this additional prestige to its product line, finds that by producing all of the models, including the standard models, is a profitable pricing line, product line. That pricing strategy may, in the end, increase the demand for all of its products. But in a sense, the users of the standard product are cross-subsidizing the users or the purchasers of the more deluxe units. Of course, in a competitive market that's not regulated, there's no regulatory approval of such pricing. Utility pricing model is considerably different. Pricing of regulated utilities is subject to regulatory approval requirements. The basic model is fairly straightforward. Costs, which are essentially the operating expenses, the taxes, and depreciation, those are the basic costs that it faces. Then a revenue requirement is created by taking those costs and adding to it an allowed return on its capital. I should point out that those costs are fairly stringently reviewed by the regulator, and of course the allowed rate of return on its capital is equally a regulated quantity. The pricing may differ by service class, but no service class can be sold below cost. That's the principle of fair and non-discriminatory pricing. And in the end, we basically have a situation in which the sum of all the revenues collected across all of its classes is equal to the revenue requirement. I want to just talk a little bit about the role of cost allocation in utility pricing. The mechanism by which we determine the costs that are to be associated with each of the service classes is done through what's known as a cost of service study. Cost of service study basically allocates costs to service classes, and those costs are based on the principle of cost causation. You allocate costs in proportion to the service class causing the cost to be incurred. In a way, this is merely a kind of, and pardon the stylized version of it, dividing up the pie among the different service classes.
Phil, let me stop you there for a moment. As we were preparing for this presentation, it occurred to me that we might think a little bit more about the notion of cost causation. So for example, suppose that I'm a customer who is located next door to the power plant versus customer 2 who is located 10 miles away from the power plant. There's obviously some extra cost associated with serving customer 2 because you have to have a much longer power line to get the power from the plant over to that customer. But in some sense, isn't that cost causation issue really the result of the initial plant siting decision? So how do you account for that?
So there are two different situations to think about relative to that kind of cost causation. If that customer, because it's sited near the power plant, takes its service at a higher voltage level, then its costs will be lower than the customer who's far away, because in fact what will happen is all of the costs that are associated with the voltage levels below which it takes service is not included in the pricing for that customer, the rate for that customer. On the other hand, though, if that customer who is far away and the customer who is near are taking their service at the same voltage level, there'll be no distinction, in fact, unless there's some requirement for line extension for the very far customer, between the rates that those customers face if they are part of the same service class. In general, we do not differentiate at this point in time geographically. So long as the customer is taking voltage at a level consistent with all the other customers, we don't geographically differentiate their rates. There are, in fact, now some proposals. There's a pilot rate project offered up by San Diego Gas and Electric in California, in which they are considering doing some form of geographical pricing associated with the charging of electric vehicles and differentiating the rates based on the likely congestion associated with the circuits that are associated with charging electric vehicles. But otherwise, generally there's no geographical distinction among customers so long as they're taking voltage at the same, the service is being taken at the same voltage level. The chief mechanism, by the way, for differentiating among costs and creating the service categories for customers is essentially something that's known as a load shape. A load shape basically describes a customer's consumption of electricity over time. What we have here is a kind of picture of the load shape of the consumption over the course of a day of two different customers. The customer in red is the solar customer. The customer who is in blue is the non-solar customer. There are a few things to take from looking at this diagram. The first is that you can see that at periods of the day, the solar customer's generation needs are quite minimized by virtue of the dip in its consumption during part of the day compared to that of the non-solar customer. But I would also point out that the non-solar customer and the solar customer's peak, that is, their maximum usage, is roughly the same. And in fact, in some ways, in this case, the solar customer may be placing a larger burden on the distribution system than the non-solar customer is because of the timing of a peak that occurs. It can also be clear that if these two customers are part of the same service class of customers, the contribution to revenues of the solar customer will be considerably smaller than that of the non-solar customer, to say nothing of during this period of time, it's likely that the solar customer is probably putting generation onto the distribution system, whereas the non-solar customer does not. Since largely the rates that residential solar customers and residential customers generally face are volumetric, the net result is that, and that includes those portions of utility costs which are fixed. What will end up happening is that deficiency in revenue is likely to produce a cross-subsidization between the solar and the non-solar customers as a result under volumetric rates.
Phil, the other thing that I found interesting about this chart was the fact that the solar customers' peak occurred somewhat later in the day, rather as compared with the non-solar customers. What explains that phenomenon?
I'm not positive because I don't have all of the data, but my guess is that the solar customer probably has a higher level of consumption in the absence of the solar unit. And as my evidence, the basis for my suspicion of that is, if you look at the consumption of the solar customer in the hours towards the end of the load shape, you can see that the solar customer is consuming more than the non-solar customer, and at the right side of the graph. And at the left side of the graph, something similar is happening. And what you're seeing, in essence, is the impact of the solar generation on its consumption. And that in the absence of that solar generation, the peak consumption by the solar customer would even be higher than on this graph. I'm going to assume that the utility is considering implementing or has already implemented a tariff for solar customers, in which some of those customers may view adversely. And so I'm going to talk a little bit about the different perspectives that arise around such a potential rate. The DG customer, the solar customer, usually will argue that the utility already provides subsidies or cross-subsidies in various ways, and imposing any differential charge that affects the DG customers is unfairly discriminatory. The non-DG customer, by comparison, will argue that the relative cost of service is overseen by the regulatory commission or some regulatory authority, or for unregulated utilities, a fair and democratic process for electing the board. On the other hand, it will also say that the cost allocation follows generally accepted industry standard practice.
Now, when you say that, is there any agreement among utilities to follow this generally accepted industry standard practice?
I'm glad you asked that question. Could we have the next slide? You're a great straight man. So some utilities may have a history of so-called, in the past, of load building rates to reduce total unit costs and overall rates. For example, declining block rates were very common for residential customers, and there have been favorable rates for industrial. The question that sort of needs to be posed to the utilities in thinking about these things and looking at their past history is, was there provided economic evidence that these past rate structures did not yield rates that were below the marginal cost of service for providing that service, or provided some support for the fact that these did not harm other customers. Also, utilities have a long history of offering rates tied to technologies, not just solar. For example, there have been all-electric home rates, and there have been special rates for ground source heat pumps, for example, to promote efficiency of electricity use. Again, the question will be, were there marginal cost studies or other studies that showed that the rate structures that were proposed held other customers harmless? There are, as Michael has pointed out, some standards in some sense for utilities to pursue in setting rates. For example, the National Association of Regulatory Utility Commissioners issued what's known as the Narrow Cost Allocation Manual, which has often been used as guidance for performing cost allocation studies, and is quite often cited. Equally well cited in terms of the design of those rates is a book by a professor at Columbia, a late professor at Columbia named Bonbright, who produced a book called The Principles of Utility Rates. I recommend the 1961 edition, in which he discussed basic principles of utility rates, and, for example, was a strong champion of the idea of cost causation as a basis for setting those rates. On the other hand, though, final rates to cost from cost of service can vary enormously. We know, for example, that for many utilities, the residential rates are cross-subsidized by the industrial and commercial rates. But those determinations for those kinds of cost subsidies have been made by regulatory commissions in counter to the cost of service. Also, Narrock and Bonbright are suggestive, but they're not prescriptive. They give you general guidance about how you should proceed and how to evaluate a set of rates, but they don't determine the rate per se. Arguably, there are subsidies inherent in rates always because, in some sense, rates are designed for the average customer, and since rates are based on average behavior, some rates may be such that low users subsidize high users and vice versa. High users may subsidize low users in a particular class. It's interesting because we don't think of it quite this way, but even in competitive markets, there's a kind of implicit subsidization in the form of customers who when we set prices equal to marginal cost, customers who are willing to pay for prices higher than the price set at equal to marginal cost are in some sense receiving a benefit because they don't have to pay those higher prices. Does this constitute a subsidy? Good question. Lastly, I would like to point out that a rate is a component of a tariff, and that a tariff is really a legal document. And it really is, that I know of, almost all tariffs, even if they make the most minor change of dotting an I or crossing a T, need to resubmit the tariff to the commission for the tariff to be included. So because it's a legal document, it always, at all points in time, for any form of revision, requires review by the commission. But in addition to which, the tariff not only sets up what the rate will be, but it has many, many more kinds of rules. I've taken this paragraph from the Nevada Public Utility Commission website, and you can sort of see the whole range of views, range of issues that arise around a tariff. In the past, at least, the rules and conditions of service can be an issue. There was, in the situation I know, relative to the Public Utility Regulatory Policy Act, for cogenerators, issues that were sometimes raised initially in the utilities implementation of PURPA, that barriers were placed in their path for putting in cogeneration in the form of the requirements for instituting such cogeneration and the requirements for interconnection.
Most of those were resolved, and they were primarily focused on the issue of the safety of utility workers who had to operate lines that potentially were being energized by cogeneration facilities. But nonetheless, those were issues that were raised at the time by companies that wanted to put in cogeneration facilities.
So we've been talking about some of the innovations, and particularly not so much the advent as the spreading of solar panels and other forms of distributed generation. Now let's turn to a case that involves that very topic, and this is the case of Solar City versus Salt River, now pending in the District of Arizona. Salt River is a power and water utility in the Phoenix area, and it has a territory in which it serves customers and has an obligation to serve. Solar City sells and leases solar energy systems to residential and commercial customers, and those customers then use the systems that they purchase from Solar City to generate electricity and thereby displace a portion of the electricity purchases from an electric utility. In other words, the solar electricity that they generate is solar energy that they then consume instead of buying from the electric utility. According to the complaint, Salt River adopted a new rate structure that included some additional fees for consumers who obtained a part of their electricity from their own rooftop solar energy systems, DG or DS or distributed solar generation. Briefly, all customers paid a rate per kilowatt hour plus a fixed monthly service charge. You could think about that as an access charge just to being hooked up to the grid. Customers that bought electricity from Salt River, but who were also generating some of their own electricity through the solar systems that they had purchased from Solar City or someone else, according to the complaint, saw a 65% rate increase, which includes both a reduction of bill credits that they had been receiving up until then on the energy that they sent back into the Salt River grid, as well as some other adjustments. In addition, Salt River had discontinued incentives for retail customers to install distributed solar, incentives that had been in place before. When all this happened, Solar City filed an antitrust case alleging that Salt River was engaged in monopolization. Now, an important component in a monopolization case is to define what is the market that is alleged to be monopolized. And in this case, Solar City said that the relevant market should be defined as the provision of electricity to residential and commercial customers, which includes public utilities and distributed solar systems. In other words, if the objective is to get electricity to consumers, they could buy electricity that is generated by the utility itself or purchased by the utility itself, or they could get electricity from a distributed solar system. In litigation, one of the initial things that almost always happens in an antitrust case is the defendant files what is called a Rule 12 motion, which is a request that the judge read the complaint and conclude that even if the facts stated in the complaint are true, there is no legal claim. There's no relief that could be granted on that set of facts. So the court, the defendant did file such a motion, and I'm not going to cover all of the grounds that it addressed, but one of them was that the market definition was inadequate. The court held that at least for these preliminary pleading purposes, yes, this is a pretty narrowly defined market because it excludes a number of other power sources, but it's not facially unsustainable. That is, the court could conceive that there might be circumstances in which the plaintiff could produce enough evidence to satisfy the court that, yes, this is the right market definition. There's an extended quotation from the case, but I think it's useful to look particularly at that last sentence, because that's where the court notes some of the core reasons why it thinks this might be a sensible market. Because your average customer is not going to install a gasoline-powered generator, not going to install a wind turbine, and particularly in Arizona, in the desert portion, is not going to install a hydroelectric dam on residential property. So in other words, these are not viable substitutes for buying electricity from the utility, unlike solar panels, which according to the court's reading of the pleadings, and again, this is a preliminary decision, solar is a plausible substitute. I think the other key point in that is to note that there is, if you will, there is a contestable portion of the electric demand. So yes, the utility is always there as a backup, and that's a very important point that I'm sure will play a role later in the litigation. But there is also a portion that could plausibly be satisfied by a consumer-owned solar system that would permit the consumer not to purchase that electricity from the utility. And the court said, basically, this is not an all or nothing proposition. The ability to supply some of your own demand is sufficient. You don't have to be able to supply all of your own demand. On this preliminary motion, Salt River did not contest that it held a monopoly, so the issue is whether it has engaged in willful maintenance of that monopoly through some additional conduct or bad acts. And the 2 points that Salt River made in its briefing was that there was no allegation that it was selling below cost. This is commonly called predatory pricing, and the idea of that is that you reduce prices long enough to drive your competitor out, and you then have sufficiently high entry barriers that your competitor cannot get back into the market, at least not until after you have recouped your losses and presumably made enough profit both to compensate you for the time value of those losses, as well as for taking whatever legal risk your conduct might have entailed. So that's the first point, that there was no allegation of below-cost pricing or an antitrust duty to deal. And that qualifier of an antitrust duty is important because there are some legal regimes, telecom being one, where there might be a statutory obligation to deal, and that statutory obligation comes with a regulatory structure that helps both set the terms for what the default rules, if you will, for what that duty to deal entails, and provides a mechanism for resolving disputes. You contrast that with a duty to deal that is generated solely by the antitrust laws, and that's a relatively rare occurrence, which was exactly Salt River's argument. And in addressing that, the district court relied heavily on the U.S. Supreme Court's decision in Aspen skiing. Let me explain a little bit about the Aspen skiing case so you can see how it may or may not deal with the Salt River facts. So in Aspen skiing, a case that dates back to the 1980s, if memory serves, there were 4 mountains, ski mountains or ski areas in Aspen, Colorado. And they had operated more or less independently for a number of years. And while they were operating independently, they came up with a program where you could buy a pass that was good for skiing at any of the areas. So if you were visiting Aspen, you could, on any given day, choose which area that you were going to ski in, and you had already purchased the pass that it allowed you to do that. Then 3 of the 4 mountains came under common ownership, and the owner of the 3 decided it was not in its interest to continue this program, and it discontinued it. It even ultimately refused a request by the plaintiff ski area to just buy day passes for cash. The defendant refused to do that. And so what the court concluded was, so you have this previous course of conduct that you have now discontinued. The conduct was profitable back before there were 3 mountains under common ownership and would have remained profitable. After all, cash is cash, and if they're paying full price for the day passes, why isn't that profitable business? And the Supreme Court's conclusion in Aspen Skiing was that was actionable as an antitrust violation of the antitrust duty to deal. The Solar City court, Salt River Court, reading that case said that, like in Aspen, so here, the discontinuation, at least based on the facts alleged in the complaint, was for the sake of excluding longer-term competition by preventing customers in its service area from installing distributed solar from competitors like Solar City. Now, I do want to note that the Supreme Court itself has described Aspen Skiing as at or near the outer boundary of Section 2 liability. Because basically, even a monopolist, generally speaking, has the right to decide who it wants to do business with. You only become concerned where there really is no innocent explanation. That's become the no economic basis theory of an antitrust refusal to deal creating, a refusal to deal creating antitrust liability. So although the district court was fully aware that Aspen Skiing is at or near that outer boundary, it also found that Salt River had not, at least at that point, adequately explained why Aspen Skiing shouldn't apply on the facts here. You know, the discontinuation of previous subsidies, the discontinuation of access on terms that occurred before the rate restructuring. Current status of that case is that Salt River took an interlocutory appeal. That is, the case below had not been dismissed. Salt River did not win its motion to dismiss. And nevertheless, it filed a motion for appeal. I won't deal with the procedural issues in that case, but just briefly, the current status is that it is on appeal. The key issues are the state action doctrine and whether Salt River can claim to be acting either as an arm of the state or acting as directed by state policy. Interestingly enough, the U.S. Department of Justice has filed an amicus brief in support of Solar City on this issue, but not on any other issues. The Justice Department argues for a narrow interpretation of the state action doctrine, which is an exception to antitrust liability. There is also a state statute excluding damages to be awarded as a result of antitrust violations that is at issue. And then finally, something called the filed rate doctrine, which again provides a limited antitrust exemption. Meanwhile, the case is actually still proceeding in the district court because that interlocutory appeal did not automatically stay the proceedings in that court. Salt River and fact discovery appears to have closed, although the expert rebuttal reports are due, I believe it's next week. Trial is scheduled for December with deadlines on the interlocutory briefs between now and then. And there's now a competing set of requests. Salt River has asked for a stay of the trial pending the result in the Ninth Circuit, and Solar City has said if you're going to postpone the trial, then we want to move for a preliminary injunction. So more to follow on that. Now, another case involves a completely different kind of innovation that we haven't really been discussing. And when you think about innovation, you might tend to think about it in terms of technology and new physical things. But innovation can also happen in financial markets. And I don't know entirely how innovative this is because the difference between physicals and futures goes back a long time. But in any event, it is now happening in today's power industry. So in this case, the plaintiff, the Merced Irrigation District, was in the business of generating, distributing, purchasing, and selling electricity to its customers. And Barclays was involved in the financial markets. There were two kinds of contracts at issue. One was called next day delivery of physical electricity or dailies, and the other was financial swap contracts. Now, Barclays was clearly not in a position either to deliver or to accept delivery of physical electricity, but it nevertheless traded in contracts for physical electricity. And it offset its purchase contracts with sale contracts, in other words, offsetting physical contracts. And according to the initial ruling by the court, Barclays accumulated a net loss of more than $4 million in its daily contract trading, but gained almost $35 million on its swap contracts. Barclays again moved to dismiss, but the court found that, wait a moment, this is market manipulation, and when you start out with your conduct being called market manipulation, you're not starting from a good place. But in any event, the notion was that the engaging in the practice that Barclays did made sense only because it eliminated some form of competition. It tended to either inflate or deflate market prices and constrain the market for other buyers and sellers of electricity. The court noted that Barclays' money-losing trades on the physical side had no legitimate business purpose, but they did have an exclusionary and anti-competitive effect within the market. And the court cites to the Second Circuit test, and this is what I mentioned earlier, monopolization conduct is conduct without a legitimate business purpose that makes sense only because it eliminates competition. Now we're going to turn to a discussion of some hypotheticals, and Phil, let me ask you the first one. So, and I should say these are not entirely hypothetical. There are some fact patterns out there in the real world that might be in some respects similar, but we have taken the liberty of describing them the way we want to describe them, so they are purely hypothetical. So Phil, let's say there is a residential customer who, instead of installing a solar system in his or her home, installs a combined heat and power system, or CHP, in the basement. And let's further hypothesize that this is a natural gas-powered system, meaning that the generation is reasonably reliable, or at least it is not sensitive to the time of day or the time of year, unlike a solar source. Should the utility treat this differently from solar? And would it make a difference if that home-based CHP could be controlled remotely by the utility, that is turned off or on as the utility determined rather than as the homeowner determined?
It's a very interesting hypothetical. I think that first I believe that any technology that essentially puts power back onto the grid by a customer has to be treated as a separate customer class, because there are costs and issues associated with the distribution system or even on the transmission system that require them, that suggest that they should be treated as a separate customer class. One of the questions I guess I would need to think a little bit about in terms of these customers is generally if they're consuming the power and the power is essentially being retained at the home, they look like, in some sense, a lot like what are known as backup generator customers that we have for industrial and commercial. That is to say, we have customers for whom they provide largely their own service, and so the service that's provided is a kind of backbone service by the utility to the commercial and industrial customers, so that in the instance of an interruption of their own equipment, the utility's equipment is brought into play, and they pay a fee monthly, plus a cost for the made-up generation, generally for the rate. And so they do bear the cost of the system, and they do bear the cost of the energy that's being provided to them to replace it. The control is an interesting one because the control might add value to the utility in some sense. If the CHP unit was providing more energy than the residential home used, there may be a reason for having controls. For example, it may be that you could reduce the overall burden on the system of such a system if you could control the level of the output of the unit. That might reduce the overall cost to the customer and the system for sure. So some amount of control would be useful. And in fact, in the case of solar in Hawaii, where they've had a very high penetration of solar, they've actually had to go to the point of, my understanding is, interrupting the output of some of the solar units because the burden on the distribution system is so large. So it's an interesting case. Utilities are in the wonderful position of always having to deal with new technologies and adapt to them.
After they have already made their investment decisions years ago in building a plant for a certain size to meet anticipated demand that they assumed they would have to meet because of their duty to deal.
That's correct. The utilities take quite seriously their requirements for reliability and meeting customer service, and so and the planning horizon for the kind of investments they make is much longer than those of these kinds of investments, and so they've made that commitment, you're right, and to make sure that they could serve the customers. Can I pose this question to you?
Please.
So from the antitrust standpoint, what do you think about the possibility that the utility becomes a solar panel vendor itself? And does that make a difference in some sense in point on the antitrust aspects of it?
Right, and so we're going to assume under whatever the applicable state law is that the utility would be able to sell its own solar panels in competition with some other solar vendor. So in this case, I think it raises two kinds of issues. The first is what kind of package deal could that utility offer? And here we've kind of assumed that away because we've said that the utility treats all DG owners the same regardless of their source. But if we didn't have that qualifier, then you could imagine a utility trying to offer some kind of package deal. And again, we would run into state regulatory issues if they were doing that. So that's why we assumed it out. But it also, I think, highlights what's really at issue in the Salt River case, because if you conceptualize it as we don't care who you buy the solar panel from, and in fact, if you buy it from us, we're going to make a profit off that deal, assuming we can operate our business in a sensible way. But nevertheless, when we go back to our utility side, we don't care who you bought it from. It's still imposing the same kinds of costs and risks on us, the utility, and it involves the same kind of potential cross-subsidization issues between our solar customers and our non-solar customers. So I think it highlights what people need to be thinking about, in that case. Another thing that it highlights is if you think about, forget for the moment about who the actual plaintiff in the Salt River case is. If you think about it as the consumers of electricity, how many different kinds of consumers would you think about as having different kinds of interests? So set aside for the moment the commercial and industrial or C&I customers. Just among residential customers, you could immediately think of at least three groups: those who already have solar, those who are thinking about getting solar, and those who have no interest in solar? And how do you allocate costs among those different groups? How do you conceptualize them? And I think that when you think about the utility as potentially being a seller, it helps highlight those kinds of issues. All right, we're closing in on the end of our hour, and we have received one question from the field, and that's simply the question of how are damages calculated in an antitrust action? And the answer is very carefully and using an economist. Now, the basic measure of damages, and it does depend upon the nature of the violation. For example, in a horizontal price fixing case, the theory is that the price fixers have set a price that is above what would have prevailed in the absence of that anti-competitive price fixing agreement. And you try to determine, you could, first of all, you have to figure out what the actual price was, which isn't always obvious because different customers might have different amounts of bargaining power. But you basically try to figure out what that price was, and then you try to determine what the price would have been but for that agreement. One common method is the before and after period. So you look at what prices were before the conspiracy started, and you look at what they were after the conspiracy ended. Another method can be called the yardstick method. You look at a different industry to try to figure out what prices were doing in that industry to determine what they ought to have been doing in the industry at issue. The important point then to add is whatever those actual damages are, you then multiply by 3. Why the number 3? Well, that's because that's what the statute says. And then the prevailing plaintiff is also entitled to an award of its attorney's fees, which can get to be very substantial as well. And I believe that is all the questions that we have received. I want to remind you of a couple of points. First, again, if you are looking for CLE credit, please do fill out the form that was sent to you yesterday and return it to Dorsey, to dorseyu@dorsey.com. And if you are a New York lawyer, please use that number as well. This webinar is one of a series of webinars that the Dorsey & Whitney Energy Industry Group is hosting, and we thank you for joining us today. We hope you will join us for future programming as well. If you have any questions concerning this program or other energy industry matters, please don't hesitate to reach out to us using the contact information that is provided on the last slide. Thank you very much for listening.